Good afternoon, everybody. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. I'd like to welcome you to today's presentation on the New York Paid Sick Leave Proposed Regulations. Today's presenters are Carrie Langen, she's a member in our Syracuse office, and Teresa Rosneck, who's an associate in Rochester. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of the screen. And if you would take a moment to complete the survey once the webinar has ended, we would appreciate that. So to get us started, I'm going to hand it over to Teresa.
All right, good afternoon, everybody, and thank you, Kathy. So as Kathy mentioned, we are going to be talking about the proposed regulations that have been set forth by the New York State Department of Labor regarding the paid sick leave statute. As we all know, the paid sick leave statute becomes effective for use purposes starting January 1st. So we are slightly less than a month away for the real effective date of that beginning. We had been waiting for proposed regulations or at least more information from New York State regarding some of the lingering questions that we had on paid sick leave implementation and the parameters of that law. Yesterday, December 2nd, the New York State Department of Labor released proposed regulations. Usually we see regulations released in the New York State Register, which is the official place that regulations are released. We didn't see that here. Those were actually posted on the New York State Paid Sick Leave website. So I'd encourage all of you that haven't had a chance to read through those to go ahead and check that out. It's just on the same section as you would find the FAQs and the other general information on the website. I will note, and Carrie and I will be talking about this throughout the presentation today, that the regulations we're discussing are proposed. They're not yet final, and when we talk about proposed regulations, they do not yet have the force of law. One or two unusual things have occurred with these proposed regulations. As I mentioned, they weren't published in the place we would normally see them. And also, there doesn't appear to be a notice and comment period set up for employers or other interested parties to give feedback to New York State about what the scope and breadth of the regulations are. If you remember a couple of years ago when we had the paid family leave proposed regulations, we did see a notice and comment period along with those where employers and others were able to give feedback, and then prior to the final regulations being released, we saw some of that feedback taken into account by the Department of Labor, and that affected the final regulations. We were thinking that that might be the case here as well. That does not appear to be the case yet. I'm not sure if it will be. Right now, all we have are the proposed regulations on the website. We don't have, as of yet, a notice and comment period set up for employers. That, of course, does raise the question of what effect these proposed regulations have, and what impact you should have in your minds when you're reading through them as it pertains to your employees and your policies. As I've said, they're not final. They don't yet have the force of law. There is a provision in the New York State Paid Sick Leave statute that gives the Department of Labor the authority to bind employers through guidance and through regulations. So when you keep an eye on these proposed regulations and you're looking through them, I urge you to start thinking about, if these were to become finalized on or about January 1st, how they would affect your employees and your business in general. So next slide, please, Kev. So the proposed regulations set up a bunch of different things. They talk about the size of the employer, they talk about accruals, they talk about documentation, but the first thing we're going to talk about is definitions. So as you remember, the New York State Paid Sick Leave statute set up a number of different terms and different ways that paid sick leave can be used, and the proposed regulations define some of those terms. So we're going to start off with the net income definition. If you remember, the New York State Paid Sick Leave statute provides that employers with 4 or fewer employees and a net income of less than $1 million must provide 40 hours of unpaid sick leave. And those with 4 or fewer employees and $1 million or more in net income must provide 40 hours of paid sick leave. So that really left open the question of how is New York State defining net income in this situation? And up until yesterday, we didn't have even a sense of what that definition was going to look like. But the proposed regulations do define net income, and they do that by linking to the New York tax law, section 208, part 9. And that defines net income as the total net income from all sources, which shall be presumably the same as the entire taxable income for the employer. There are exceptions and more information. I couldn't include them all on this slide, otherwise this would turn into a tax lecture, and nobody wants that. But there is more information in that section of the tax code that I cited there if you're trying to figure out what your net income is for purposes of whether or not you have to provide paid or unpaid sick leave. One of the other things that the proposed regulations define is confidential information. If you remember, the paid sick leave statute prohibited the disclosure of confidential information as a condition of taking leave, and we weren't really sure what that meant. You know, if employers couldn't require the disclosure of confidential information, could they ask why the employee was taking leave? Could they get medical documentation? You know, what did confidential information really mean? And Carrie's going to talk more about the documentation side of the confidential information definition, but the proposed regulations do define confidential information as any individually identifiable health or mental health information, including but not limited to diagnosis and treatment records from emergency services, health providers, or drug and alcohol abuse prevention and rehabilitation centers. The proposed regulations also state that confidential information includes information that is treated as confidential or for which disclosure is prohibited under another applicable law, rule, or regulation. So if you're not allowed to disclose it under a different law, rule, or regulation, you're not allowed to disclose it for paid sick leave purposes either. And again, Carrie will talk a little bit more about that when we get to the documentation side of things. But it generally means that the documentation that you can require and the information you can require from an employee pursuant to the use of paid sick leave is going to be rather limited. It's going to have specific parameters around it, and you're not really going to be able to ask for any type of specific information about the nature of the illness or the emergency that's putting the person out on leave. Another definition that we got from the proposed regulations was mental illness. If you remember, one of the reasons that the New York State paid sick leave statute said that you could take paid sick leave is for the mental illness of an employee. We didn't have, or an employee's family member, we didn't have a definition of mental illness either from the guidance or the statute, but the proposed regulations do set up a definition of that. And they do it as they do with many of the definitions in the proposed regulations by linking to another section of the New York law, in this case, the New York mental hygiene law, where that term is found. So if you look at the New York mental hygiene law, section 103, part 20, mental illness for that law and for purposes of paid sick leave means any affliction with a mental disease or mental condition which is manifested by a disorder or disturbance in behavior, feeling, thinking, or judgment to such extent that the person afflicted requires care, treatment, and rehabilitation. So that's our definition of mental illness. Again, that's going to be very broad. Another definition that we got in the proposed regulations is preventative medical care. If you remember, one of the reasons paid sick leave can be used is for the preventative medical care of an employee or an employee's family member. The person doesn't have to have an active injury or illness to be able to use paid sick leave. So the proposed regulations do give us a definition of preventative medical care, and it's rather expansive. It means routine health care, including but not limited to screenings, checkups, and patient counseling to prevent illnesses, disease, or other health problems. So very clearly, paid sick leave can be used for preventative medicine purposes. It doesn't have to be an active injury or illness bringing you to the doctor. Finally, the proposed regulations define family offense. As we remember, even though it's called paid sick leave, you can actually take that leave for what we would more consider to be safe time, or things related to domestic abuse, stalking, sexual offenses, any kind of family offense experienced by an employee or an employee's family member. So for the first time in the proposed regulations, we see a definition of family offense. As is the case with the rest of the definitions, the majority of the definitions, it links to another section of the law, in this case, the New York Family Court Act. And the proposed regulations do say that it'll qualify as a family offense for paid sick leave purposes where the acts as defined by the New York Family Court Act, are between current and former members of the same family or household. So that includes, as a family offense, some of the things you might think of, and maybe a couple that you wouldn't necessarily think of, but that's disorderly conduct, harassment, sexual misconduct, forcible touching, sexual abuse, stalking, criminal mischief, menacing, reckless endangerment, criminal obstruction of breathing or blood circulation, strangulation, assault, and attempted assault, identity theft, grand larceny, or coercion. So a pretty broad list of reasons that you could consider to be a family offense sufficient to qualify an employee to take paid sick leave. And then I didn't go through and define them on here because you can find them in the proposed regulations and the laws they reference, and I didn't think they were quite as relevant as the definitions we did include, but the proposed regulations also do talk about human trafficking, sexual offense, stalking, and domestic partner. Those are all defined in the proposed regulations by reference to other parts of the New York law or regulations. So those are our definitions. When it comes to what definitions you should include in your policies, I'd urge you to have at the beginning of your policies, if this is something that you think would be appropriate, just to have a section of the definitions so that employees know, when you say you can take leave for a family offense, what precisely that means. I don't want anyone to be in a situation where an employee claims, oh, I would have taken leave, but I didn't know I could take leave for that reason, right? It's easy to avoid that by including those definitions in your policies. So moving on from definitions, I'm going to talk briefly about what the proposed regulations said about accruals. So, and this is, I think, inherently one of the more confusing parts of the proposed regulations. So please bear with me and we'll try to get through it. As you know, since the moment we saw the first paid sick leave statute language, employee accruals of leave were on a 1 hour accrued for every 30 hours worked increment, right? That's been our increment since this started. You get 1 hour of paid sick leave for every 30 hours that you work. And until these proposed regulations came out, we had every expectation, or at least I had every expectation, that if you worked less than 30 hours, there was no need to give you a partial increment of leave time for that time. You got 1 hour when you hit 30 hours. If you work less than 30 hours or fewer than 30 hours, you didn't get that 1 hour or any increment of 1 hour until you hit that 30-hour mark. The proposed regulations do change this, and I think this is one of the more significant changes in the proposed regulations. So the first thing the proposed regulations say about accruals is when calculating accruals for time worked in increments of less than 30 hours, employers may round accrued leave to the nearest 5 minutes or to the nearest 1/10 or quarter of an hour, provided that it will not result over a period of time in a failure to provide the proper accrual of leave to employees for all the time that they have actually worked. So this and the language on the next slide do seem to be indicating that you can have increments of paid sick leave accruing when an employee has worked less than 30 hours. So the question really is, what does this mean? Does leave, in light of this language, accrue on a per minute basis? I did some fast math and determined that would be about 0.2 seconds of paid sick leave per minute of worked, or 12 minutes of paid sick leave each hour. Is that what the statute is now contemplating? Is that what we have to do? I give an example here, and I think this is one of the more straightforward ones that you can give. An employee of ABC Engineering works 40 hours in a week. For that week, the employee accrues 1.3 hours of paid sick leave. Previous to these proposed regulations, we might have said that an employee would only accrue 1 hour that week and would have to wait until the employee worked an additional 20 hours in addition to the 10 worked in the first week before they got to another hour of paid sick leave. But this language in the proposed regulations seems to contemplate the opposite, that even if an employee has only worked part of the 30 hours, they're still going to get a partial hour amount of paid sick leave. And so that really does leave the open question of how often must employers reconcile paid sick leave banks? We were thinking that you only had to reconcile the bank every 30 hours up until we saw these proposed regulations yesterday. Now, it really is an open question. I think employers are well advised to reconcile the paid sick leave banks at least weekly by letting employees know how much paid sick leave they have on a weekly basis. Could it be more frequently than that? I think it could be. We simply don't know at this time, and hopefully this is something we get more clarification from New York State on, either in the final form of the regulations, which we are still expecting because these, as I've mentioned, are just proposed, or we've had some information from New York State that they intend to issue additional FAQs dealing with the topics that the proposed regulations address. So perhaps we'll see an example or two that might illuminate this concept in there. But that's kind of where we are for now. I think, for those employers, and I've heard from a number of them that are having accruals on a monthly basis, or on a quarterly basis, I think you need to be, especially in light of this language, particularly careful of that. Really, you need to be reconciling that leave at least every 30 hours, and in light of this language, quite possibly more frequently than that. So that's my part on accruals. I'm going to turn it over to Carrie now to talk to you about our next topic.
Great, thanks, Teresa. Great, thanks, Kathy. So we finally have some information on the documentation that can be requested. So if an employee is out for 3 consecutive work days, you can require documentation from either a medical provider or from the employee. And I'll explain that in a minute here. But what we thought was interesting was the way the language is written. It says that if it's 3 consecutive days of previously scheduled work days or shifts, I guess I don't really know what the previously scheduled work days is intended to mean here. But, because I think if somebody is not scheduled to work, they wouldn't be using paid sick leave anyway. But it opens up the question of, what do you do about per diem employees? Because they're not necessarily scheduled. So we just wanted to raise that. Again, hopefully there will be some more clarification there. But I think what's important to note is that employers can now request documentation if somebody is out for 3 consecutive days. The other point here that we wanted to raise is that employers cannot require the employee to pay any cost or fees associated with obtaining the medical documentation. So, again, that's just something to be mindful of. If it costs the employee, $15 or something to have the doctor fill out, complete a note to submit to the employer, we can't require that the employee pay for that. They can be reimbursed for that cost. Next slide, please, Kathy. The request for documentation, it's limited. So we can either ask for a note from a licensed medical provider, but all the note can say is it can support the fact that the employee needs sick leave, address the amount of leave needed, and the date the employee can return to work. So there can't be any information on the note about a diagnosis, treatment. It strictly has to just say, Joe Smith, was out the last 2 days for sick leave purposes, and he may return to work. It's very generic notes that we can request. The other thing that you can do is, if you don't want to request a note from a medical provider, you can request an attestation from the employee that just states that they were eligible for leave or that they were using that day for paid sick leave purposes. Next slide, Kathy. Thanks. The employer, again, so we can't disclose the reason for leave, and we can't require the disclosure of confidential information. And Teresa explained earlier what confidential information means. So I think we just want to be sensitive to the fact that these notes, again, should be pretty generic, but it is at least something that we can require from the employee if they're out for 3 consecutive days. The employer, again, just more detail on this last bullet here, we can't require that the attestation explain the nature of the illness or any details related to domestic violence, sexual offenses, family offenses, human trafficking, or stalking if the employee is using the time for safe leave as opposed to sick leave purposes. Next slide, please. There is now some guidance in addition to the documentation. We have some guidance on employer size. So how to count the number of employees for purposes of determining how much sick time you have to provide. So if you have less than 100 employees, you only have to provide 40 hours. And if you have 100 or more employees, you have to provide 56. And so how do we calculate that? Now, the proposed regulations say that it's calculated by counting the highest total number of employees at any point during the calendar year. So I think that's going to be important. You know, if you have seasonal employees, you're looking at your highest point of the calendar year to date when you're determining your threshold number. And this does get a little bit confusing. The regulations do kind of address what happens if in the middle of a calendar year, you switch from 40 to 56, let's say, hours. And, you know, again, a little bit ambiguous. I hope that we get some better guidance on, you know, exactly what the Department of Labor is trying to say here. But our best interpretation is what I'm going to explain here. And the way I'm going to do it is through an example, because I do think it's a little bit tricky to figure out, you know, what's kind of going on here. So ABC Engineering had 75 employees in January of 2021. But in June of 2021, they reached the 100 employee threshold. So what happens, right? And just to note here that let's assume that ABC has capped usage of PSL for 2021 at 40 hours. So employees get 40 hours because they only have 75 employees. Now recall that the carryover is technically still unlimited. You know, spoiler alert, but we haven't told you that yet. But these proposed regs do not address carryover, unfortunately. So assuming the carryover is unlimited, ABC is capping the usage at 40 hours. So what's going to happen once they get to 100 employees? And what we think the proposed regulations are saying is that once you reach 100 in June, the employee has to be able to accrue the 1 hour for every 30 hours worked up to 56 hours or 7 days, as opposed to the 40 hours. But the employer can keep the capped usage at 40 hours for the remainder of that calendar year. So the employee can accrue more time, but can't necessarily use it. Now, remember, they can carry it over into 2022. So presumably this is so that the employee can then use that time in 2022 that they've accrued from June through the end of 2021. And again, it's the extra 2 days because the employer went over the, into the new threshold of time. Next slide, please, Kathy. The proposed regulations also say that prior accruals of used and unused paid leave can be credited by an employer toward any increased paid leave obligations. So what we think that means is if an employer already gives more than 7 days, say they give employees 10 days per year on January 1 of that year, you can credit that time toward the 7 that you're now going to need because you've suddenly gone over the 100 employee threshold. And then lastly, employers may not credit any prior accruals of unused paid leave toward any paid leave obligations. So if an employee has, used unpaid leave, prior to, because there was no, they ran out of paid sick leave, you don't have to credit that time back. You can just kind of do it on a move forward basis. They would get 2 additional days moving forward. Next slide, please. In terms of employer size, some additional information on who's counted, to get to the 100 employee threshold. The proposed regulations say that employees on paid or unpaid leave, including sick leave, leaves of absence, suspension, or any other type of temporary absence are counted, right? As long as you have a reasonable expectation that the employee is going to come back to work, you would count them toward your total head count. You count part-time employees. Part-time employees are considered to be employed each working day of the calendar week. And probably most significantly, the proposed regulations say that employees that are jointly employed by more than one employer have to be counted by each employer, whether or not they're on the employer's payroll. And so if you have temp employees through a temp agency, those employees now have to be counted toward your employee count, even though they're not on your payroll. You get them through a temp agency. So we think that's a significant development here that could potentially impact a lot of employers. The fact that you have to count temporary agency employees toward your threshold number. And then obviously employees who are terminated are not counted. Next slide, please. What was left unanswered? Again, I mentioned this earlier, unfortunately, probably what everybody was waiting for was not answered. And that's, can we cap carryover, or can we eliminate carryover altogether if the time is front loaded? Because it's not necessary to carry over time when you're front loading the full allotment on January 1 or at the start of the calendar year, because use can be capped. So unfortunately, we did not get any guidance whatsoever addressing that. So our advice, has been and will continue to be that the way the statute is written, employers technically have to carry over time from year to year and cannot cap carryover. Even if you're front loading time on January 1st, let's say, of 2021, you still have to carry over time from year to year. The other thing that wasn't addressed, unfortunately, is how to calculate the regular rate. That's still not defined. And then lastly, nothing in the proposed regulations at all about collective bargaining agreements, how to handle them. So, those are the three things that were left out. But, we did get some guidance. So we're thankful for that, for what it's worth. Again, as Teresa mentioned a few times, these are just proposed regulations. So, what effect they have, remains to be determined, I guess. When the regulations are final, these proposed regulations may not all have the force of law. So, and of course, we'll update you, if we hear anything about a notice and comment period, or, when we ultimately get final regulations. Teresa, was there anything else you wanted to add?
I want to address a couple of questions I saw in the chat, Carrie, while you were talking. So probably our most common question, and I apologize, I should have mentioned this at the beginning, is will we be sending out the slides and or recording of the presentation? Yes, to both. Those will be sent to all people, everyone who's on the presentation or signed up for the presentation shortly after it ends this afternoon by our marketing department. So you will get those. One of the questions I saw that came up a lot, Carrie, and I think you can speak to this because it was on your part of the presentation, but if you're going to be using paid sick leave concurrently with FMLA or paid family leave or something like that, does the confidential information prohibition, ban you from getting the information you need to designate paid family leave or FMLA? I don't think so. I don't think anything in this statute overrides the obligations found in that statute, but I'll let you speak to that.
Yeah, no, I agree, Teresa. And I even think that there was some language there in the proposed regs essentially saying that, unless it's required by another law. And so if we can get this information because we need it for FMLA or PFL purposes, I don't think that the confidential information provision in PSL is going to prohibit us from doing that.
Yeah, and then another question we got a lot is, with this change in the accruals or this proposed change in the accruals, what does this mean when an employer, front loads, say 80 hours of leave at the beginning of the year? Does this still mean that we can combine paid sick leave with paid time off? And I think it does. I think it just means we have to track, whatever you're calling it, paid sick leave or paid time off that can be used for paid sick leave purposes. I just think it means we have to keep a closer track on the accruals, right? But I don't think anything in the proposed regulations overrides the provision in the statute that says if you have a policy that's more generous than what the statute requires when it comes to use carryover and accrual, that's going to satisfy the requirements of New York paid sick leave. So, I didn't see anything, and Carrie, you can jump in if you disagree, in the proposed regulations that would prevent an employer from combining paid sick leave with paid time off, as long as you're careful about the accruals.
Yeah, no, I agree. And I think if you're front loading the full amount, say you have over 100 employees and you're front loading the full 7 days, then you've satisfied your obligation to give the full 7 days. And remember, when you're talking about accruals, the time is accruing at 1 hour for every 30 worked up to the maximum of 7 days. So if you're providing that up front, I don't think you have to worry so much about the accruals, aside from, the technical requirement that you have to tell employees how much time is used and accrued if they ask for it within 3 business days.
Yeah, I think that's an excellent point. And I think if the accrual provision in the proposed regulations does eventually become finalized and has the effect of law, the most administratively convenient thing for employers to do is going to be to front load that leave when you can, because it eliminates some of the headache of tracking as closely as you would with any type of accruals. But we're a little past 12:30, so we're not going to keep anyone. As I said, the slides and the recording will be coming at you this afternoon. Carrie and I thank you so much for joining us. As always, we will keep you updated as further developments happen, as we become aware of them. So thank you, everyone, and have a nice rest of your day.
Thank you.